If you guys will get yourself situated, and then we'll do a really quick sound check. We'll start with the state.
Testing. Can you hear me?
Yes, thank you very much.
Thank you. And Mr. Michels.
No.
Testing.
Yeah, now I can hear you. Thank you.
Thank you. When you're ready, you may proceed.
Thank you. May it please the court, counsel. You can go get an independent test done at your own expense. That took 3, maybe 4 seconds to say. How is it unreasonable to require an officer to make that advisory, especially after a person has made a statement that implicates or inquires about a secondary or an alternate test? I think in analyzing this case, it's important that the court have an understanding of the context and purpose of the right to an independent chemical test. The right to an independent chemical test is rooted in 2 fundamental rights: the right to preserve evidence for the defendant and the right to present a defense. Additionally, it's rooted in fundamental fairness, which this court has basically stated that is one of the cornerstones of the criminal justice system. In State v. Rodriguez, this court held if a defendant puts his mental capacity at issue, the state is entitled to an independent evaluation of the defendant. That was not decided based on any statute or rule, but solely on fundamental fairness. Here, the legislature has identified and articulated the right to an independent chemical test, and they have codified that. So we have a statute to base this on. In essence, the state has their evidence. The defendant should have a fair shot to obtain his own evidence. And the reason that the legislature codified the right to an independent test is because it understands that OWI cases are unique as opposed to all other criminal charges under Iowa law. And it's unique for 2 reasons. The first being that the test result is determinative evidence of someone's guilt. The second being, particularly with a breath test case, the sample is gone as soon as it's tested. Looking back, you're going back to the determinative evidence of guilt. In a breath test case, the only evidence the state needs to present at trial to obtain a conviction is the test result that shows somebody is over 08, or in the case of a drug, that there is a controlled substance detected in the system. In addition, the statutory scheme, as well as this court in State v. McIver, has stated that if an officer is faced with a breath test under 08, the state can continue testing the defendant as long as the officer believes that the person may be under the influence of a drug or a combination of drugs and alcohol. So essentially, the state can continue testing an individual until they obtain a failing result. Additionally, if we look at the sample being gone, that is unlike any other.
Mr. Michels, in terms of your reasonableness point, which is a good point, there is a right to an independent test, but there's not a right to be told there's a right to an independent test. I mean, that's the way the legislature wrote the statute and what we've said in the past, correct?
Yes and no. I mean, in Bloomer, I guess Bloomer is what's being used to say that you don't have to be advised. However, all we have to do is take Lukens, the ruling from Lukens, the holding, and change out the names here. I mean, if we look at it.
I don't know that that's true, and here's why. So in Lukens, the defendant says, can I have a retest or reblow or recheck, whatever it was. The officer says no. Doesn't tell him about the right to an independent test. Here, and so where the officer says no, but doesn't say you can't have that, but doesn't say here's what you can have, that's arguably maybe misleading because the first no suggests that there are no other options available. But in this case, your client asked, can I have a retest or reblow, recheck, whatever it was? The officer said yes. And your client changed his mind and walked out the door. So, in that circumstance, what's misleading or unfair to the defendant? That I don't see that because he was offered exactly what he asked for.
I certainly appreciate where you're coming from here. The problem I have with it is that, one, of course, the officer is going to tell him, I mean, it makes sense for an officer to tell him, yes, go ahead and take the test. He's taking advantage of an unwitting defendant. This court has stated a defendant does not have the right to a recheck on the breathalyzer. That's what he asked for. So that is outside the scope of the statute. So that's what I think puts it on all fours with Lukens. The fact that the officer is required to advise does not turn on whether or not he tells him yes or no, according to the holding in Lukens. The holding in Lukens states that once somebody makes a request that is outside of the scope, the officer must advise them of their right. It says nothing about only upon if they tell them no, they're not entitled to that. And here, an officer, we're running down a really slippery slope if we allow an officer to just say, yeah, you want a second breath test? Sure, I'll give you that. Because he's taking advantage of an unwitting defendant. The defendant is potentially providing additional evidence against himself to the state. And this is not what the purpose of this statute was meant for, to allow the state to obtain additional evidence.
Maybe the recheck would have a different number, a better number. I mean,
anything's possible, but either way, I mean, theoretically, if you wanted to look at it, the state can use that any way they want. Or arguably, then the state...
so could your client if it was favorable to him.
But
right?
then also the state could potentially be arguing, well, you're not entitled to the second breath test on the state machine, so now it's inadmissible. Now we get into an issue with that. Is it admissible because he's not entitled to that test? Because that's what this court has stated. So I think that creates some huge problems. And additionally, if we look at it in the terms of the way 80420 has been used, there's a huge difference there. I mean, I understand the court says if somebody asks to call a friend and the officer says, yeah, go ahead, he doesn't have to advise them of the ability to contact an attorney or a family member. But it's different in that context because the defendant's ability to contact a friend does not help the state, and it does not hurt the defendant. Here, taking another test, another breath test, and the officer being able to just say, yep, that's what you want, go ahead, he's potentially hurting the defendant by now, and the state benefits by obtaining that additional evidence of potential evidence of guilt against him. So I think that's a huge problem if we allow officers to just say, yep, okay, we'll grant you the second test. Because what this court stated in Lukens and what we've said in the context of 80420 is individuals don't necessarily know the full extent of their rights. They may only have a vague idea of what their rights are. And so that's why people need to be advised.
But the legislature knows how to spell out advisories. It's done that, and it stopped short of saying, tell them about the right to an independent test.
I understand that as well, but again, we don't have that. I mean, law enforcement's been required to advise people of all kinds of different rights. Miranda rights. If the officer wants to question them, they have to advise them that they have the right to remain silent. The same with 80420 rights, and this court has always tied that back to there being a fundamental right, the right to counsel, the right against self-incrimination. Again, that's what we have here, is there's a right to preserve evidence for the defendant. There's a right to present a defense. And OWIs are really unique in that that breath sample is gone as soon as somebody blows into the machine. And we're working on a very short amount of time for when somebody can get an alternate sample. You have the right to present evidence in your defense, but when you don't have a sample available to you to give to an expert, to have it independently tested and subjected to strict scrutiny, ultimately, we can look at Escobedo v. Illinois. Prosecutor says, yeah, give him the best defense, give him the best experts in the world, because the conviction is all but assured by the breath test. That's what we have here. They walk in with a breath test. Casper's not advised that he can go out and get his own evidence, that he can...
Do you agree that if he had not asked for a second breath test, the officer would have no obligation to tell him about his right to an independent test?
The way the case law is currently, yes. I mean, he doesn't have an obligation to advise him unless Casper, like he did, implicates the statute. And like I said, I think all we have to do is take the language, the holding from Lukens, and swap out names. As with the statutorily impermissible requests in DiDonato and Garrity, Casper is not entitled under Iowa Code Section 321J11 to take a second crack at the breathalyzer machine. Nevertheless, his statements, reasonably construed, indicated he wanted another test, even if he was mistaken, unsure, or unaware of the way in which the additional test would be conducted.
I know, but here the logical conclusion is he probably didn't want another test, because when he was told he could have exactly what he wanted, he changed his mind and walked out the door.
Well, that's certainly one way that it can be interpreted. The other way could be he had some idea that he was entitled to another test, but when he found out that this officer was going to be the one administering the test on the state's machine, now he wants no part of it. Because, and that's the if you look at it, the officer certainly can be setting him up to dupe him. Either Mr. Casper takes that test and he provides additional evidence that can be used against him, or, as what happens, he walks out the door thinking that the breath test is the only option he has available to him, because he was not advised.
Counsel, why isn't there harmless error here?
First of all, there's not harmless error because this is a general guilty verdict of OWI first offense. If you look at that guilty verdict that the district court put together, it says, I find the defendant guilty of OWI first offense in violation of 321J.2. That's it, okay? Secondly, prejudice is presumed. The state has the burden to prove that the evidence complained of was not considered in making that decision. Here, obviously, the breath test was considered. There's an entire paragraph devoted to the breath tests. And I say tests because the court also improperly considered the PBT result. And we obviously have no idea to what extent those test results provided any credibility to the other evidence that the court considered.
Can I ask a follow-up question?
Certainly.
Regarding the line of cases involving a general verdict, are those distinguishable, or does it all matter here? We have specific written findings by the district court, which I think we treat more as a special verdict. And we can clearly understand the basis and the rationale for the district court's findings, contrary to what would happen in a jury trial. So does that make that line of cases, the Ho-Grief line of cases, distinguishable?
I would say that it's still a general verdict, because ultimately the court, we don't know what the court, I mean, yes, in a perfect world, we're supposed to understand when the district court lists its findings, what exactly they're thinking. But if you look at Moorhead, the court held that that was a general verdict, that it was not harmless error. And the facts there are a heck of a lot stronger as it pertains to, is somebody under the influence? I mean, the defendant admitted that he was drunk as hell. We don't have that here. And ultimately, we don't know The district court does not specifically say it did not consider the breath test results when it found Mr. Casper guilty. And I think this court needs to be overly cautious when entertaining harmless error when the violation precludes a person from preserving evidence that they could then present on their own behalf as their defense. And especially in an OWI case where the availability of that evidence is a very short window. So again, I think those are, I don't think that this was harmless error because it is a general verdict. And we don't know exactly, the court did not articulate whether or not it was considering the breath test because at the verdict, because it only actually says, I find him guilty of OWI, first offense, in violation of 321J.2 as alleged in the trial information. And if we look at the trial information, the state alleged all three alternatives: under the influence of alcohol, under the influence of a combination of drugs and alcohol, and over 08.
If you'd like to wrap up.
Sorry. And so for those reasons, we would ask that this court overturn the Court of Appeals and the district court and remand this back for a new trial. Thank you.
Thank you. Mr. Sloven?
Thank you, Madam Chief Justice, and may it please the court, counsel. None of what he just said is true. I apologize for using my cell phone, but that's where I have the record. Look at page 42 of the appendix. You have a written verdict from a stipulated trial on the minutes. Justice McDonald, you're correct to note that we generally treat that as a special verdict, not a general verdict. First, the district court lays out the different alternatives for proving this OWI charge, and then in a single paragraph describes the facts surrounding the traffic stop: 110 miles per hour on a motorcycle in a 55, bloodshot watery eyes, slur thick tongue, and then gets to all of those factors together. Hasn't mentioned the breath test at all, or the PBT. All of those factors together demonstrate that due to the ingestion of alcoholic beverages, defendant's reason or mental ability was affected, his judgment was impaired, and he had, to some extent, lost control of his bodily actions or motions. At time of operation of the motorcycle, the defendant was under the influence of an alcoholic beverage. Then talks about the breath test on the other alternative, the over .08 alternative.
I mean, this is the second time this has come up today. I mean, I'm starting to get pretty uncomfortable with these trials on the minutes where the state is now arguing harmless error. I mean, the whole point of the trial on the minutes, you would agree, is to allow the appeal on the suppression motion, right?
Well, there's also a benefit at sentencing because the court doesn't have as many facts as would be developed at trial before it. And there's a hope to get some sort of concession out as part of a deal in conceding to a stipulated trial on the minutes. And Iowa doesn't have conditional guilty pleas. So if there's a guilty plea—
Right now it doesn't, but it may, yeah.
If there's a guilty plea, it's intended to be a lid on the box. If there's a trial, then we're going to have findings of fact on each alternative charged. And if that's maybe there's room for the defendant to reach a stipulation with the state about what exactly they are stipulating to and what they are disputing, but that didn't happen here. We had a trial on a stipulated record and findings of fact establishing proof beyond a reasonable doubt, which, I mean, what other result could you have gotten from these facts? Proof beyond a reasonable doubt that he was under the influence. I mean, his statements, his speed, we don't need to go into all of that because the district court told us it found his intoxication beyond a reasonable doubt without any consideration of the breath test. So harmless error, let's talk about 321J11. The argument that you can just swap out the names and that this is identical to Lucan's is incorrect. Justice Mansfield, you noted that in Lucan's, the request for a retest was denied. And the takeaway from Lucan's read together with DiDonato is when confronted with an imprecise invocation of a statutory right, the officer cannot stand mute and deny the request, right? And you're correct that the reason that that's bad is that it's misleading. It conceals the existence of the statutory right when it would be the natural thing to mention as the way for the arrestee or detainee to have some sort of vindication of the interest that, right? Somebody's like, can I call my second cousin? And the officer just says, nope. And obviously in that situation, it's unfair not to tell them who they can call. If they ask for a retest on the data master and the officer just says, nope, it's unfair in that circumstances not to tell them, but here's how you can get a test if you want one. It's very different when the officer grants the request even though it falls outside the scope of the statute. That's what we've said in 80420 cases. Otherwise, what you're just doing is basically creating a trap for the state. And you're allowing suppression of results based on the denial of a right that doesn't actually exist, based on over-granting a right, based on a polite acquiescence to a request that, you know, falls outside of the technical scope of the statute, but seems reasonable to the officer, and why not, right? And so he asks for a reblow on the data master. He says that data master machine as he's leaving, and the officer says, sure, need your driver's license. The officer's gonna put the information back in the machine, and he changes his mind and leaves. So we're not in a Lucan situation. This is a situation where the officer tried to grant the request, said, sure, you can have exactly the thing that you asked for, right? That's difference number one. Difference number two is that in these 321J11 cases, the reason why the person needs to be told that they have a right to an independent test is because usually they're in the custody of the state or detained in some way, where their ability to go out and get evidence of their own is somehow constrained. When right after this conversation, he leaves, right? Now, let's just say right before he walked out, he said, hey, can I call my lawyer? And the officer said, well, sure, the phone is this way. And he said, no, never mind. And then he walks out, right? When he walks out, is it a violation of 80420 for the officer not to tell him that he had a right to call his lawyer or a family member under 80420? No. Well, first, he's not at the place of detention anymore after he leaves. But you would, on a common sense level, you'd say, well, when he walks out with his wife, he can call whoever he wants, right? The officer is no longer in a position to prevent him from making any call that he wants to make. The analogy is not perfect, but I hope that it illustrates that after he leaves the station, right, where does he go with his wife? Wherever they want to go. Nothing that the officer said or didn't say about you have the right to go and, you have the right to contact an attorney after you leave here. You have a right to go get an independent test. You have a right to go and have a burrito. He can go and do any of those things that he decides that he wants to do. He's at his own liberty. The state, and so the core interest implicated by the statute, by that point, has evaporated. Once he's released on bond with his wife, who has a car and drives away, and he can go get an independent test if he wants. He can call a lawyer who can tell him, help him, connect him with an independent test. He can take any other steps that occur to him to preserve evidence. Now, it is refreshing to hear a stated interest in the preservation of breath test evidence on a closing time window after the arrest for OWI. But really, if we were talking about this in the context of the destruction of evidence or loss of evidence, then in order for that to be a claim anyway, there would have to be some sort of showing of a reason to believe that the destroyed evidence would have, either it has to be destroyed in bad faith, or there has to be some reason to believe that negligent destruction of it caused the loss of evidence that would be favorable to the defendant. And I don't see either of those happening here. That's not the claim that's being raised. I just wanted to point out that even if you were going to compare this to the kind of, the young blood type cases where we're talking about destruction of evidence, that interest really isn't implicated here. That, I think,
Counsel, was Lucan's correctly decided?
Well, it's an interesting question. There's some debate about whether it was adding or in fact, contravening the words in the statute by creating a suppression remedy. The statute seems to foreclose that by saying that failure or inability of the detainee to obtain an independent chemical test isn't grounds to exclude the test performed by the officer under implied consent. I think that am sympathetic to the idea that if somebody asks for an independent test and the officer just says no, I don't really know what the remedy for that would be other than suppression. I do think it's problematic, though, that the statute specifically disavows that remedy. So I think that Lukens is debatable. I don't think that this case calls for us to overrule Lukens. I think that the district court applied Lukens correctly. Also, the district court's ruling is defensible on Wooten, which was the grounds on which it was made. The state urged the argument that I'm making now. Otherwise, error wouldn't really be preserved for it. But that was argued at the hearing on the motion to suppress. But it is also relevant that the request for an additional test was made almost a full hour after the initial test, and at the very just down to the minute of that 2-hour limit. And I think that it is not. I think that it is. I'm sorry, the finding that that is an unreasonable delay before the second request is supported by substantial evidence, and you could affirm on that basis too.
The problem with that argument is, but he says yes, the officer says yes, so you're saying, well, he'd actually unreasonably delayed.
Yeah, I think that it would be that the officer, that whatever the officer said at that point, that no answer could have created a violation of the statute at that point because the request was too late. There is one more thing that I want to mention, and that is that taking the test on the data master could create evidence that would be worse, that the state could then use, that would be worse for the defendant than if the defendant went and had an independent test. I'm going to give you 2 citations real quick. State versus District Court for Lynn County, that's 218 Northwest 2nd, 641. And then there's also State versus Bedell, and that's 193 Northwest 2nd, 121. Both of those cases establish that when a person goes and gets an independent chemical test, that the results of that test are not privileged, that they are relevant, discoverable evidence. So if he goes and gets an independent test and it shows the same thing, that's still evidence the state can use. So I think that no matter who performs the test, it's going to be fair game for both parties to use it as evidence, whatever it happens to show. I think that the real statutory, or the interest that this statutory right protects is the ability of the defendant, if they decide to get a additional check of that result. But because, as you pointed out, the legislature wrote this statute in a way that doesn't affirmatively require an officer to include this in the list of things that they explained during implied consent. The intent is to create a right that's available to people who, if this is a concern that the defendant raises, that the detainee raises in that moment, that, and the reason that it's not of greater concern is that these machines, we have administrative rules and procedures, and we check their accuracy meticulously. And if there is a concern about accuracy, I mean, we have the technical readout, right? All these implied consent invocations, they come with a tech readout of the statistics of the machine and its calibration and its margin of error, and this is suitable for review after the fact, even though, all of the breath that I'm breathing now is going to evaporate and dissipate, and it can't be recovered. But the words that I'm saying are being recorded. It's just like that, where you have a record of the test and a record of the machine input that you can then go and re-examine. And if the defendant raises the concern, that's when the statutory right is implicated. But it's not intended to be used as a trap for the state, as is being done here. So that's all I have to say. If there are any other questions, I'd be happy to answer them.
Thank you.
Otherwise, thank you.
Mr. Michels?
Sorry. Thank you. First and foremost, I would like to point out that in the district court's findings of fact and finding of guilt, nowhere in there will you see the words beyond a reasonable doubt. It is not there. It is not in those paragraphs that the state points to where district court says he is under the influence of alcohol or anything like that. Furthermore, I would like to point out that those findings that the court has, the court does not tie those specific things individually to the elements of under the influence. Furthermore, it's the state's burden of proof to prove the guilt beyond a reasonable doubt. There is no evidence as far as that of under the influence there. There's no evidence of intoxication. There's evidence of consumption, but that's it. There's a difference between consumption of alcohol and intoxication. You can consume alcohol and not be intoxicated. And so if we look at those, speeding 110 and a 55 doesn't mean you're intoxicated. Bloodshot
Aren't we
water-
talking about impairment, though?
Yeah, I mean, but that's the issue is how does speeding, what does that have to do with loss of bodily actions or motions, judgment impaired, stuff like
Driving 100 and a 55? Wouldn't that be judgment?
Could be, but people also do that when they've stone cold sober. There's plenty of
But
people
even a
who
stone
speed.
cold sober person, wouldn't that be a reflection on their judgment to go 100 and a 55?
It certainly could be, but is it due to alcohol consumption?
Well, does impairment require, I mean, isn't that kind of why that impairment statute's there? Because in cases where someone does refuse a test, there won't be a chemical test. So other indicators, wouldn't that be a,
Right. What I'm saying is just the simple fact of speeding does not mean that alcohol caused that impairment, okay, or caused that lapse of judgment. That's what I'm getting at here. And additionally, the HGN test, the 6 out of 6, the state did not prove what 6 out of 6 means. Most tests, if I took in school, if I scored a 6 out of 6, my parents would have been happy with me. There's no evidence as to what that 6 out of 6 means or anything that the district court cites to saying what that result means, that means impairment.
Just to clarify, when there was a stipulation of trial on the minutes, it didn't include like the DVD as part of the stop, right? Was
The
that
stipulation
part
to
of
the trial on the
minutes?
minutes, no.
Yeah, so it's just the minutes, just the written stuff.
Correct.
Okay.
runs when they want to stipulate on the record, that's another way of saying, and I'm not going to respond to anything. So if the state puts that out there, wouldn't it be defensible?
Mentions that the officer administered the HGN and he scored a 6 out of 6. That's what the findings of the district court were. Moving on, Justice Mansfield, as far as the harmless error issue, I think you're right. Without us having, defendants are put into kind of a catch-22 here. The purpose of the trial on the minutes is to allow us to preserve an issue for appeal and be able to appeal that. But judges in these types of cases are appeal-proofing themselves to where we can, we don't have that opportunity then to get these issues in front of the court when judges are appeal-proofing themselves here. Other things I would like to bring to the court's attention is the state mentions how—
Counsel, I'm sorry, I can't hear you. I think your mic may not be on.
I'm sorry, can you hear me now?
Can you hear yet, Justice Apple? Say something again, would you?
Can you hear me? It's on green.
Would you turn off and then back on? Do another
Justice
test.
Apple, can you hear me?
Can you hear me, Justice Apple?
I'm sorry, I still can't hear.
How about me?
Yeah, now I hear you.
Okay, now you try again, sir.
Justice Apple, can you hear me?
Yeah.
Okay,
Yes, thank
you know
you
what,
very
just a
much.
minute.
That's fine.
I'd like to give you a little more time. Would you please add another minute to his time? Sorry
Thank
about that, sir.
Thank you.
Additionally, the state argues that Mr. Casper was not, you know, that the advisory only applies when a defendant is in custody. Mr. Casper was in custody. The record is clear on that. He is inside a locked portion of the jail. While his wife has arrived and has posted bond for him, he's not free to leave at that point. He has to be let out of a locked door. So therefore, he is still in custody, and that's what this court has held is when there's the disparity in power, which we have here, he's in custody, and the request is outside the scope of the statute, that's when there is a duty to advise somebody. And that's exactly what we have here, which is why we can just swap out the names in the holding of Lukens. Additionally, just to briefly touch on the timing.
How would you respond to the state's argument that the interests of the statute aren't implicated where the defendant is imminently going to be released from custody? So he does walk out the door shortly thereafter on his own liberty, and he's free to do what he wants.
Well, I would also ask, has he implicated it while he's in custody? Yes. And so therefore, there is that disparity in power. He has no idea. Mr. Casper may think he's being released, or he may be thinking, who knows what happens if I say the wrong thing or do something wrong. Now, all of a sudden, am I going to get charged with something else? Am I not going to be allowed to leave? We have no idea what's going through a detainee's head, because there could be hundreds of things. But at that point, he's still detained. And it's not until he's released that he now is free to go do whatever he wants. He's still under the control of the state at that point. And so for those reasons, we would again ask that this court overturn the Court of Appeals and the district court's decision and remand for new trial.
Before you step down, I have a question. I know the time ran. We were talking earlier about the fields, and you were saying just the basic minutes. But the minutes make reference to the officer's report, and included in the officer's report is the field intoxication report, which breaks down physical observations. It also talks about the field sobriety testing, and it has a narrative about that by the officer. And there's also the OWI interview report, which should also be part of it. So there's more information than just the cover page of the minutes of testimony. Correct? Show that impairment?
Yeah, but what I'm saying is the state has the burden to prove what 6 out of 6 on an HGN means. Otherwise, without them proving that, it's just, that's all it is a 6 out of 6. What does it mean? That's what they have to prove. And so that's why I posit it that way, is that there is not sufficient evidence there, as like there was, like in Moorhead, there's more sufficient evidence for a finding of beyond the reasonable doubt than there is in this case. And in Moorhead, we held that it was not harmless error. Thank you.
Counsel, do you happen to have the citation for Moorhead written down right there offhand?
I do have Lukens, so I know it is listed in here. Just bear with me a second here. So Moorhead, 699 Northwest 2nd. I have the later site in here at 672.
Thank you.
So that should get you there. Thank you.
Thank you. The matter of State versus Casper is submitted, and we are hereby adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.